Good. Music in the classroom. This is actually one of the topics that I think led to this entire presentation. We've gotten many calls that resulted in very unpopular answers.
The NSAA put out some guidance on this, like don't violate copyright laws, if you remember. What was that, last year maybe? At some point anyway. So it became a buzz in the education community.
All right, so we're going to start off with 4 hypotheticals about music in the classroom. First two teachers asked to play music in the class. First one, English teacher wants to play classical music from Pandora while the students write and take tests. She has studies that show that listening to classical music while working improves performance. What if she uses the radio? Does that make a difference? We then have the shop teacher just wants to play some rock and roll in the background from Pandora while the students work on projects. What if she uses the radio? Does that change anything? Our third one, we've got the school's therapy dog ate the sheet music. The band teacher needs to make 100 copies before the concert tonight. Can she make those copies? And our final one, nobody likes to warm up or watch players without warm-up music, so Bobby fires up and blares some Barbra Streisand, his favorite artist. Music over
they're not funny.
I spent an embarrassing amount of time last night trying to make Bobby's Bitmoji dance. I will tell you, I failed, but just imagine that in your brains and it will entertain you even more.
But they're playing that over the sound system during warm-ups. Does the school need a license for that? There's not too many ways to sexy this up. These are the guidelines from Circular 21 that comes directly from the Copyright Office. Permissible uses. You can make emergency copies to replace purchase copies. That would be one. A second one is academic purposes other than performance. You can make a single or multiple copy of the excerpts of the work. The third one is printed copies, which have been purchased, maybe edited or simplified with some certain restrictions on there. The fourth one is a single copy of recordings of performance by students can be made for evaluation or rehearsal purposes and may be retained by the school or individual teacher. And the final one is a single copy of sound recordings may be made by an educational institution or an individual teacher for the purpose of constructing oral exercises or examination. So those are your 5 permissible uses under the music in the classroom. The prohibitions, copying to create or replace or substitute. Again, the anthologies, compilations, or collective works, they don't like that. The consumable exception, again, you can't make copies of workbooks, exercises, things of that nature. Copying for performance purposes other than we just talked about. Copying for the purpose of substituting for the purchase of music. Again, don't steal is basically what that is, except as we said in the emergency exception. And then copying always has to include the copyright notice on the printed materials.
Ms. Hazy.
So we did, this will not surprise you. We divvied these slides up last night, and you see I don't have anything in front of me because I just don't go that way. And the guys had the over/under on how often I said, "Is this you? Is this me?"
Instead, she just didn't do that. She's done 4 of mine and 3 of Steve's. So.
Have I really?
Yes. Steve and I have our own side action going on this, by the way.
That's horrible. So if you want to play music in the classroom, basically the older the better. When we say the classics, we don't mean the Stones. We mean like Mozart. And the more highbrow, the better, because again, the older the work is, the more likely it is it's in the public domain or it's not protected by the Copyright Act. Here's the bottom line: most performances of copyrighted songs require a license. You just playing Taylor Swift because we need to shake it off and shake our booty. That's a copyright violation, pure and simple. You can rearrange, edit, or simplify a copyrighted work if you're a music teacher, and the riff on the Stones songs is too hard. You can rearrange it. But you can't alter the fundamental character of the composition. And you can make a single recording of a kid practicing like your district music contest or just to show how awesome our music students are. But you can't sell that or stream it for public entertainment. It has to be for educational or archival purposes. Is this me?
Yep.
Okay. I want you to make a little check mark by these next 3 slides because we're going to circle back to this when we get to the speech team. But in terms of music in the classroom, this is a executive for legal affairs with one of the publishing companies saying, performing a live song to demonstrate technique is okay, playing a CD is okay, all of that would fall under the educational face-to-face exception. So the face-to-face exception says the performance has to be initiated by instructors or pupils. So this won't cover your, the traveling Shakespeare companies. They have to have their own way to be not violating the Copyright Act. It has to occur within the context of face-to-face teaching activities. So the kids singing their district music contest piece for the teacher to see if it's good enough to compete in, that's covered by this. And when they go to district music and they go in that little classroom and perform to get a 1 or a 2 or a 3, that would be covered by the face-to-face exception. You see the weird geographic requirement in the 3rd bullet point under the performance must be. It has to be in a classroom or a library or a studio. It literally cannot be in the auditorium, can't be at the nursing home or any of the other places, because it has to be in a place devoted to instruction. Once you get into the face-to-face exception, then there's no restrictions on the type or amount of copyrighted work that can be performed. So if you're going to sing Taylor Swift at district music, you're cool, as long as you aren't going to perform it at the end of district music for parents' night. But for the actual district music contest, you can use copyrighted music. Can't be used for somebody brought in from the outside, cannot be given for the recreation or entertainment of any part of the audience. So I'm nervous about parents' night. Can't be part of profit making, and it can't be in an auditorium or school assembly, because then they say, look, now you're doing a class play, so you should have to pay the author. That's not an individual doing this just for an instructional purpose. So that face-to-face exception is helpful as long as you keep in your brain that it's basically a kid learning how to perform and doing it in a small setting like a classroom or the library or the music room, something like that. Still me?
Still you.
A student performing at a school concert, so this is your elementary music contest, or a music concert now, parents coming in to see the kids perform. You can't charge admission unless you've paid the performance copyright fee for that music. And the copyright owner, if they hear about it, can actually write to you and say, don't perform. This has happened actually a few times in New York public schools where like the long-haired music composer is actually living in the same town where the performance is going to take place. They can send you a notice saying, we don't want you to perform it. I've never had this happen in Nebraska because, Imagine Dragons doesn't hear about Lexington doing their songs at their concert. So that's the one way that we can get out from under the school concert exception. And the last bullet point, this only applies to music, not dramatic works. Again, this is not a way for you to get around paying the public performance license for your one-act play or your fall play. It only applies to music performances for concerts. Again, the choir concert in the spring, the elementary Christmas concert, that kind of stuff. So here's the question. Does it fall under one of the exemptions if it's in the public domain? You don't have to worry about copyright at all, but 9 times out of 10, somebody more recently has rearranged that music, so be aware of that. Does it fall under fair use? Does it fall under performance at a concert? You can't charge admission, remember that. Or if you charge admission, it can be only for an educational, charitable, or for charitable purposes. So a musical play requires the public performance license. So again, I know those get expensive, but there's really no way around it. It does not exempt, that does not apply to the band playing at the pep band. So you're gonna have to have a public performance license for your pep band music. And this is a really good resource that from the Music Educators Association that has good, like how to do all this stuff without violating copyright. The Music Educators Association is a really good resource all the way around. We actually don't have problems with music teachers. It's sports and sometimes drama teachers, because they don't get as good a training on dance teams. Yeah, actual straight music education, they tend to do a pretty good job.
And you've been buying boxes of the sheet music for a long time, right? That's I view it sort of like textbooks.
Yeah.
That's your music classroom textbook to some extent. So you've always typically purchased any of the rights that you would need anyway. So yeah, but these same concepts, trying to apply them to other areas is a little,
it gets a little tricky.
Yeah. Okay. So here's the question. May a music teacher put on a recital of songs performed by the school choir and charge an admission fee? May a parent video the holiday concert for personal use? May the school record a student performance and post it on the school's website? And so 2 teachers asked to play music in the classroom. We're going back now to I think that might have been duplicate. Anyway, sorry. 2 teachers asked to play music in the classroom. The English teacher wants to play music from Pandora. She absolutely has studies, research, which will say that it will improve student test scores and all that sort of stuff. That's great. I think that research does actually exist. We think you still need a license. I don't think it's fair use because she's not teaching how Mozart scores a requiem. She's playing Mozart's requiem while the kids are taking a test. So I don't think you've got a fair use in that context.
Now remember, I said the older the better and the more highbrow the better. So you're saying to yourself, well, wait, she should be able to play Mozart on Pandora because that's old. But the problem is it's probably like the New York Philharmonic performing Mozart. And so somebody rescored Mozart's, there's no harpsichord in this or whatever, there's no cloggers. I don't know what all's in there. But most of the time, somebody recently has put their hands on that music to have some kind of derivative work. So just because it's old and highbrow doesn't mean that we're automatically safe because somebody has probably updated it for this performance.
Right. In other words, what Steve was talking about when we first started, the public domain website, that might well apply to the very original work, right? I mean, that original Mozart work obviously is out of any sort of copyright protection. But when you are getting it through Pandora, it is probably somebody else performing it, which means they now have they probably paid, if they needed to, performance license, your teacher didn't. So when it comes through Pandora, Apple Music, Amazon Music, one of those, you got a whole new set of issues.
Now we're getting text messages. Thank you, you're making me happy. We'll answer all these in a chunk.
Yeah,
Keep going.
so not least of which, I think one of your problems is the extent to which their terms of service for things like Pandora, Apple Music restrict performance, right? So I know there are classroom options available out there, which is good, right? If you get Pandora for Classroom, that's great because Pandora, right, the reason you're paying for it is because they've done the vetting work on that to make sure you're not using it in an unlawful way. If the teacher just loads up his or her own personal Pandora, and if you Google Pandora in the classroom, the first website that pops isn't stop, make sure you're not violating copyright. It's here are the 16 best playlists to use if you're a music teacher, if you're somebody who wants to play Pandora in the classroom. So the universe out there, if you're just leaving your teachers to wander through it, isn't real clear. It makes it look like, oh yeah, you can totally do this.
If you are going to not prohibit teachers from playing Pandora in the classroom, the third bullet point, is it a public performance? I think we need to do as much as we can to get within that exception. So I would say that the teacher should only play it for the students in his or her classroom. The teacher should probably close the door, which hopefully they're doing it anyway. The teacher should talk about how much they love these children and whatever. Because we want to make it as much like you had a party at your house and people came over and you happened to have some background music on. We want to make the classroom look as much like that as possible so that we can at least argue if you get sued that it's not a public performance.
And that it's not played every day, right? And that it's true. If your research is indicating to play it for tests and you're playing it every day, we've lost any real argument that this is anything other than for personal enjoyment,
right?
Which wouldn't be permissible. That'd be like blaring it, in the warm-ups at a basketball. Okay, so we're coming to that. So what if she uses the radio? Does that make it any better?
It actually makes it worse because the radio station has paid for the public performance of the songs, but you have not paid the radio station for the broadcasting of its on-air talent. So now you've got two potential copyright violations: the music license holder, because you didn't get permission from them, and from the radio station.
So how about the shop teacher? Again, wrong. And I think you lose any sort of educational argument in the case of the shop teacher just wanting to have music on in the background. And again, you're still getting colder if she's using the radio. How about the school's therapy dog eating the sheet music? We think that one comes out differently because of the circular, right? There's nothing in that circular that talks about playing Pandora. There might have been if the circular wasn't developed in 1976. But now we do know for sure that making things like emergency copies is permissible. That's, again, because of the guidance from that circular, not because it's just objectively clear in the law that you can do that.
And notice that it doesn't matter if it's an emergency and it falls under the circular, the quantity doesn't matter. A lot of times educators would shy away from 100 copies because they'd be like, I don't know, that feels wrong somehow. If you are under one of the exceptions, the volume doesn't matter.
Right. Yeah. For whatever reason, making 2 copies feels less violative than 100. But if it's a violation, it's a violation unless you're falling under one of the exceptions. So how about the warm-up music? We think this is a public performance. It's the reason the NSAA has either intentionally or unintentionally put all of you on notice that you shouldn't be doing that.
Yeah, so that NSAA notice was basically like, hey, if you're going to play warm-up music, check and make sure you're doing it right. But they didn't tell you how to do it right, you notice, because it's really hard to find a way to make sure that this is okay.
Yeah, there isn't a great answer. You need a license. I think that's the bottom line. Now, the variety of responses we've gotten from these music company copyright enforcers has been across the board. We've had 2, maybe 3 entities who have actually gotten some sort of contract license, ranging all the way from, no, you absolutely can't play our music. In between has been things like, oh, you're a public school, we don't enforce against public schools. Of course, none of which is put in writing. So it is entirely possible that if every one of you calls these different music representative companies and asks, I need to get a license for basketball warm-ups, will you provide that to me? You're probably all going to get somewhat different answers.
We literally had one school get a license, and then another one of our clients called the same company and said, hey, we want a license, and they said, we don't do that. We sent them a copy of the license that their company had sent out to the other school, and they're like, yeah, we don't know anything about that. It's extraordinarily frustrating.
Yeah, the representatives must work on some sort of commission basis because you got different answers from different people. So the frustrating part, and why we, to be perfectly honest, hate doing copyright presentations for a lot of reasons, is because we're very solution oriented, and there just isn't a good one in this context.
We do have one solution,
This
which
is-
you
this is
won't
Karen's
love,
solution.
but your local DJ has a DJs get a license for public performances of the music that they play. So if you're really committed to having warm-up music and you're willing to pay, or you got a local DJ that'll cut you a deal, a local DJ that is playing using their license should be able to play, because they only have access to certain libraries, so they're going to know what they can and can't play. That would be one way to get this music out. In fact, we have one client that for their senior graduation video, they have the pictures up on the screen, and they hire a DJ to play the music that goes with it, so that they are not violating copyright law when they have that senior music video.
Yeah, we have the same concerns for if you're striving your games, for example, and that's picking up the background music. So for a lot of reasons, there are a lot of different complicating factors which aren't getting easier. And we hope maybe someday the music industry will just throw a blanket exception out there for schools playing for warm-up music, but that hasn't happened.
There is actually a law pending in the federal Congress to kind of give some more guidance about music and copyright. I have not dug into it entirely, although it would include some kind of more universality in the licensing. The problem is I don't think anything's going to happen in Washington, so I don't want to invest a ton of time in learning it, but we do have that on our radar and we're tracking it. If it passes, we'll let you know.
So we put these up here for literally every copyright presentation we do. I honestly don't know how helpful it is, but one of the difficult parts is, let's say that your basketball team puts together a playlist that has Taylor Swift and Imagine Dragons and somebody else. It's entirely possible you're actually going to need 3 separate licenses from 3 separate companies, because there's not like one place that you go to find all licensed music. So this adds to the complexity of it. Again, we apologize for not having great answers, but
We're trying.
you roll the dice in a lot of other areas. So if you're like Bobby, I'm going to keep playing Pandora before the basketball game, that's up to you and the board. If they ever find out about it, I guess
We'll fight like hell to defend you.
We'll fight, but I don't know that there's any other great answer out there.
Okay, so this has generated lots of text messages. Thank you. That helps me know that you're out there still listening with us. So thank you very much. So the question about the school concert exception or the public performance exception, what about a board member who thinks we should put a donation bucket out at our concerts? That does not automatically make you charging admission, but just make damn sure, because when I've done a couple of these where it's like donation, there's an aggressive patron standing at the door saying, hey, it's a $10 donation. And then they shove the bucket in your face and you feel like a jerk if you don't put $10 in the bucket. So if it's just sitting there passively, I do not think that constitutes charging admission. But if you've got somebody like functionally suggesting that you should pay, that's when you lose that exemption. So I'm okay if the bucket just sits there and you let the Holy Spirit guide their hearts, but you can't give the Spirit a shove, if you know what I'm saying. Somebody asked, what about Strive? Strive in general, I'm cool with. Striving the music concert, one of us did some research on that. Wasn't that you, Steve-O?
I don't believe so, but
I have at various times, and to be perfectly honest, as a lawyer, we all struggle with this. The A+ law school answer is you would absolutely not strive your music concert unless you know that you've got any number of the potentially, half a dozen licenses, which might be required for you to do so, because you're blasting that out on the internet. It's no different than if you record it and post it on YouTube, right? YouTube will send you a takedown every time unless you can certify to them that you've got the licenses required to send it out to the universe. the live nature of it, the concert exemption, the face-to-face stuff, that really doesn't apply when you're taking it and broadcasting it out to the world. You become a TV broadcaster.
Our best bet is to argue the school concert exception. That's where we would go if one of you got a takedown notice because you strived your concert. So at a minimum, please don't record it and archive it on your Striver account and let people come back, because then the more permanent it is, the worse. But the problem is that school concert exception is specifically key to it occurring in the physical location of the school. And once we're striving it, we're not in the school anymore. Now, grandma and grandpa love it. Like my mom has really big mobility issues. The ability to listen to stuff on Strive is huge to her. I get it. So it's a calculated risk, but I think we would lose that.
The other thing that I think you should think about that's a lot of things in one sentence. You ought to think about looking at the music when you purchase it. So if you're going to purchase a certain song to be played at the spring concert or to be sung at the spring concert, ask that person from whom you're buying it if you are able to broadcast it on your school's YouTube channel or Strive or whatever it might be, because you can always buy the appropriate licenses, and with the representation from the person selling it to you, that's probably okay.
So, for example, all of the cartoons we have here, we can buy them to use in slides, but we also can buy an additional amount of license to post them on social media and on websites. So we pay that bump up. So there may be some additional cost to including the rights to broadcast the concert, but it may be worth it because I know that Strive is part of like an important part of some of your cultures. Anything else on Strive? Somebody just texted OMG.
It happens out there.
Yeah.
I mean, we know
Yeah.
what happens.
Yeah.
And the Taylor and the work those guys are doing is really cool. We love it. We support it 100%. It's hard for us to give the A+ law school exam answer, which doesn't tell you shut it down, which is why we don't like to do that. But yeah, it's a calculated risk.
What about radio stations playing through business sound systems? I had this case. This was one of my first jobs as a lawyer. The Wilbur Hospital got a takedown notice because they were playing, I think it was KTAP radio, the radio station I worked at in high school, was playing the radio over the sound system. So the senior partner that gave me the assignment was like, this is BS. You send him a letter telling him to go to hell. And I did the research and had to go back and tell the client and the senior partner that you can't just play the radio station over the sound system. Now the radio station has a broadcast license, so the radio can play no problem. But when you amplify it back through your own sound systems, you are now violating the copyright law. You'll notice when you go into big chain stores like Forever 21, the music they're playing over their speakers is canned. They are not playing the radio for this very reason, because your license, the radio's license, does not include rebroadcasting in other businesses.
Bars, same sort of thing. That's why they pay so much money for jukeboxes and all that.
We have ASCAP. Does that help protect playing music for sports? Absolutely, as long as you are only playing ASCAP licensed music. But that's fantastic. And that's the way to play it. If you can get a license from one of these publishers, that's great. How do we get around music in the classroom? How can I legally play music while my kids work? Yes, we feel your pain. In fact, we hashed it out again yesterday as we were talking about what to say here. These guys say don't do it.
We say get
Which
the
is
right
right.
license. There are places that you can go to get classroom. Now, might not be exactly what you want, but I think there are ways that you can do it. I don't know that you're going to be able to turn on your favorite Pandora station and play it in the background.
So, and then the tail end of this is, do I need to purchase a Pandora account? You need to purchase a Pandora Classroom account, which is one step up from an individual account. If you are bound and determined, you've heard us and you say, okay, I don't care, I'm still playing music, then do as much as you can to make your classroom when you're playing the music like your home. So close the door, don't do it all the time, have it keyed to specific activities. But unless you have a Pandora Classroom account, we can't guarantee that you're gonna be cool. We'll defend you hard. Can students listen to their own Pandora accounts during study hall with earbuds? Yes, they can, because now that's not a public performance.
Personal enjoyment.
And that license for an individual, they individually have the license to listen to it, even if they've got the free Pandora account, because they have permission from Pandora.
Yeah, go read the Pandora Terms of Service, and you'll be surprised at how many things they put in there about these exact questions.
So this is why I love superintendents. Now I have a follow-up question on Strive. Can striving the concert be homework? Can it be like the media class's job is to strive the concert? You're getting closer. The problem is most of like homework, that would be the face-to-face exception. And remember that has to happen on school grounds in a classroom or not an auditorium, but you're getting closer.
And to be clear, we've got no problem with a basketball game broadcast that doesn't have any of the background music that you're maybe unlawfully playing for warm-ups, but has your students calling the
Talking.
play-by-play
Now you're good.
and recording your game, right? FERPA allows that because you're not disclosing it. It's student records to the extent that it is, you can disclose it. It's when you're combining it with the music that you have to pay to broadcast out. Otherwise, you'd put radio stations out of existence if all you had to do was say, oh, we got kids doing it, right?
Yeah.
That's just not how it works.
Is there a Pandora account for athletic events?
I don't know. Not that I'm aware of.
We have research to find this Pandora classroom license level, so we'll do some digging. I think we would have found it if it existed, but we'll look. My fear is that there's not, because what they're going to be worried about is that like everything that the university plays at Husker football games, they've paid for, and they paid out the nose for it. And I'm fearful that they're not going to have like an athletic event license because they're not going to want to let Notre Dame and Nebraska get over on them. But we'll look. We'll look, and if we find the answer, we'll blast it out.
They overpaid for the last couple Tunnel Walk songs, in my opinion, but that's neither here nor there.
All of you that gave me crap about my predictions.
Moving along.
We do
Now,
have a comment on the chat. ASCAP and CSAC,
CSAC, yeah.
CSAC, do not sell licenses to high schools. They called them out last week after receiving the NSAA memo. So
ASCAP, but they lied to you because one of your peers has a license from ASCAP. They just talk. So yes, I agree that when you call, sometimes they say, "Oh no, we don't." First they say we don't sell licenses to high schools, and then they say we don't enforce against high schools, which is a lie because sometimes they do sell licenses and sometimes they do enforce.
Yes.
Now the fact that you made that phone call is money, because remember, go back to the very beginning when we were talking about damages. Your damages are significantly reduced and sometimes zeroed out if you had good reason to believe that you had permission. So document the Billy heck out of that phone call. And if they come sniffing around, you've got that to use. But I cannot say you are golden once they tell you that they won't give you a license.
Right.
Because remember, this is about control, not about money.
Yes. And you might have to, depending on, so the links that we had up there were to the repositories of those different places. So if you've called ASCAP and if you've called CSAC and they've said the same thing, oh, don't worry, we don't enforce against public entities. Believe me, we've heard it all.
Yeah.
Unless they're willing to send you that in writing, I just don't believe it. But to the extent that you're playing music, make sure it's from their libraries, right? Don't then go to the BMI library and play
there's about
some Elton John. right?
4
Don't do that.
major publishers that hold the rights to popular music, and it all is littered all back and forth. And the superintendent that is still committed to striving. What about Spotify? Spotify, Pandora, Apple Music, they're all the same, honey. Good try.
That's why you have to
That's
listen to
why we love you.
commercials for the free version, right? I mean, they've got to pay the bills to those artists, and they want you to do the same.
This is my favorite. I love this part of doing this because I love your text.